It is very common for claims to be brought where the will is valid but certain people have not been provided for under the will. Such claims are made under the Inheritance Act of 1975. This sets out the specific categories of people who can make a claim, including spouses, civil partners, ex-spouses and ex-civil partners, certain cohabitees, children of the deceased, children of the family and adult children, anybody who may have been wholly or partially maintained by the deceased or supported by the deceased financially before their death. It is also possible to bring an Inheritance Act claim if there is no will. For example, we have acted for a number of long-term cohabitees who consider themselves common law spouses and were surprised to discover that in the absence of a will, they had no automatic right to inherit their late partner's estate. Intestacy rules are fairly rigid and old-fashioned, and as such do not allow cohabitees or children of the family where they are not biologically related or adopted to inherit. To make a claim, you would need to set out that you have a certain need. For example, details of your expenses and outgoings, and that you have the right for these needs to be met by the estate. It is also important to set out what your means of meeting your own needs are. This will include details of your income and assets. If an agreement cannot be reached between the parties, then the court will make the decision. They will weigh up a number of factors to determine what reasonable financial provision is. The court will not only look at the needs and the means of the person making the claim, but they will need to take into account the size of the estate and the needs and means of any other beneficiaries or other claimants. In making a claim under the Inheritance Act, it is important to remember there is a time limit. The time limit for making such a claim is 6 months from the date of the grant of probate being issued. It is therefore important to act quickly when making such claims. Whilst the courts do occasionally allow additional time, and it is possible to agree additional time for bringing a claim, it is best not to rely on this and to bring a claim as soon as you are able to. Because you are not disputing that the will is valid, but just claiming that you have not been provided for under the will, it is not possible to enter a caveat with the probate registry to stop the grant of probate being issued in these circumstances. If you do wish to make a claim for financial provision, it is important to obtain specialist legal advice as soon as possible.